So the case opened yesterday between Enoch, Burke and Wilson's Hospital School in the High Court. You might think that this case that started yesterday, that's the 28th of March, is just another running battle or one of the running battles between the parties, but it's not. This is the substantive case. And I myself, quite frankly, was wondering what was the substantive issue that the High Court has to determine in this case. And it's this. The school has gone to the High Court looking for an order or a determination that they were justified and in order in invoking the disciplinary process in the school and in suspending Mr. Burke pending an investigation as part of that process. They claimed that they were entitled to do that and it was the correct thing to do. Mr. Burke, on the other hand, is challenging that and saying no, he shouldn't have been suspended, and he has counterclaimed that the whole disciplinary process from the start should be basically set aside or annulled, and that it wasn't in order and breached his constitutional rights and so on. That's the core issue between the parties. And the school opened its case yesterday. It's got two senior counsel, Mark Connaughton senior counsel, Alex White senior counsel, and it's got a junior counsel, Rosemary Mallon BL, and they opened the case yesterday, and basically they were making issue or making the point that Mr. Burke's behaviour in the school, but particularly at a religious or chapel service involving the principal, Miss McShane, that he was haranguing the principal and his conduct was inappropriate and disrespectful and so on. Mr. Burke, on the other hand, is saying that his conduct was respectful and appropriate and wasn't inappropriate. Now, let me ask you this. If you are faced with a conflict of evidence between the parties as to the conduct of Mr. Burke, and that's what the judge will be facing, a conflict of evidence. On the one hand, the school is saying that his conduct was inappropriate and disrespectful and haranguing of Miss McShane, and on the other hand you have Mr. Burke saying that his conduct was respectful and appropriate. When you're faced with that conflict, which version of events do you find, or do you think the judge will find more credible? Bear in mind that the judge yesterday put his head in his hands and said, Mr. Burke, you would test the patience of Job. Bear in mind that yesterday the judge excluded Mr. Burke from the hearing that started only at 11 o'clock, or didn't actually start because Mr. Burke had preliminary objections about discovery and about emails and WhatsApp messages and so on. But between the jigs and the reels, the judge felt that Mr. Burke's conduct was so inappropriate yesterday in the High Court that he excluded him when the court rose at 1 o'clock and said you can't come in at 2 o'clock unless you give an undertaking to the court to behave yourself, to behave appropriately and to adhere to the ruling of the court. The judge yesterday said that he was in breach of, or he was in contempt of court and so on. Now bear in mind that the substantive issue, as I've just said in this case, is whether Mr. Burke's conduct was inappropriate and disrespectful and haranguing, or whether it was entirely in order and reasonable. And here you have a judge who has to make that decision, finding himself making a decision to exclude Mr. Burke from the court shortly after the hearing was to commence at 11 o'clock. If you were making a decision, if you were an adjudicator at the WRC or a judge in any court and you were looking at the conduct of Mr. Burke in the court, and if you were, as I say, faced with a conflict of evidence between the parties as to Mr. Burke's conduct in the school and whether the school was entitled to invoke the disciplinary process and suspend him, then obviously you're going to make up your own mind. You'll have to make up your own mind. There is a conflict. A couple of other interesting points arose from yesterday. One is that Mr. Burke apparently had no objection to a previous request from the school in November 2021 about a transitioning student. There was no difficulty on that occasion, according to Senior Counsel for the school, Mark Connaughton. Mr. Connaughton says that a similar situation occurred in November 2021 and the principal had issued a similar communication to staff, including Mr. Burke, and no issue had been raised. As I say, there will be a conflict of evidence here about Mr. Burke's conduct in the school, especially at that school religious or chapel event involving Miss McShane. The bishop apparently was out attending that and there was a dinner then after that particular religious service. Mr. Burke's contention and argument is that what he did and said was respectful. The school will have a different view. Senior counsel said that the school had not begun the legal action lightly, but was in the invidious position that it had a teacher who was absolutely determined not to comply with an instruction from the principal, but would not broach any discussion or compromise unless the approach he was advocating for was taken. Mr. Justice Owens then said that Mr. Burke could come back into the court if he was willing to give an undertaking that he would comply with court directions and orders. Mr. Burke had repeatedly accused the school's lawyers of tampering with documents, emails and WhatsApp messages. The school denies this, the school's legal team denies this in the strongest possible terms, and they say that they can deal with his questions or any issues that he raised in relation to documents in writing. And the judge asked of Mr. Burke, "What am I going to do with you?" and said that he would test the patience of Job. Before he rose from the bench, he told Mr. Burke, "Bye-bye to you." That's day one of the substantive hearing between Wilson's Hospital School and Mr. Enoch Burke. I'm not going to cover every day, I don't believe, but I was interested for my own education, as it were, to understand what was the substantive issue. Because remember, if somebody is dismissed from the job, then ordinarily the route that they must go is to the Workplace Relations Commission with a complaint about unfair dismissal. And that, you know, this case obviously is in the High Court. It's going on for 4 days, and I'm thinking to myself, what is the story here? What is the substantive issue? But the substantive issue basically seems to be that the school look for an order and are seeking an order, that they were in order using the disciplinary process in the school as a consequence of Mr. Burke's conduct. And Mr. Burke then is claiming and counter-claiming that the whole process, the whole disciplinary against him was inappropriate, unjustified, over the top, and should be set aside. That's it. Case is due to continue again today and tomorrow and Thursday or Friday, Tuesday. It's on for 4 days anyway. Tuesday, Wednesday, Thursday, Friday. It's on for 4 days. It will be interesting, but that's where we're at. If you find this video useful, I would appreciate if you gave it the thumbs up down below. I'm trying to just strip out a lot of the histrionics, the antics, the Highwire Act that, you know, has been reported generally, and obviously people can get carried away in the media and in Twitter and social media and so on. And I'm trying to hone in and focus on precisely what is the substantive issue, what is the issue that the judge has to determine, and if you were in his shoes, what would you decide? If you appreciate, or if you like the video or find it informative, I would appreciate it to say that you gave it the thumbs up.